welcome. I appreciate your time here today. Hopefully, I can give you some interesting information around what we're talking about. Hope you'll find it valuable, but thank you for your time. So I think let's kick off and take it step by step. So as you know, we're talking about kind of your legacy and the building block of your legacy. Anything really that you plan, your financial plan, wealth plan, whatever you want to call it, needs to have this building block in place. If you don't have your will in place, I think you almost shouldn't even start with the next steps, because this is the building block that everything pivots on. And let's see why. Okay, so from maybe I should just check can you just raise your hand? Can you hear me, see the presentation? Is everything good? Great. Thank you very much. All right, let's kick it off. I think you know who we are. What we do generally we take quite seriously, and we hope we deliver a quality product to you. And I think it shows in what we've achieved. This is the last 2 years, but we've been involved in this for longer than this. But the point is, what we deliver, we pride ourselves in, and I think it shows. What we do, I think online trading, broking, managed portfolio, structured product, offshore transfers, tax-free savings account, wealth management, depending on how you define wealth management. I think what we're talking about today is the absolute underpin of wealth management, and depending on how you define it, a lot of what we're talking about today and a lot of what you see on the screen now, I think is wealth management. Those are some of the partners we use to deliver these products to you. And hopefully when we sit across the table from you, or these days across Skype screen or a Zoom screen or Teams, whatever it is, I think what we deliver is a solution that is best of breed for our clients, and these are some of the guys we use for that particular solution potential. Next in line then is the agenda. What am I going to cover today? Well, the basics of a will. I think we just need to understand a couple of the nuances. Just make sure everybody's on the same page. If you die without a will, or your will is invalid for whatever the reason may be, and we'll chat about that. What happens then? Testamentary succession principles. We'll talk about a couple of those. The standard ones. Unfortunately, as many people as there are on this call today, everybody's will is going to look slightly different. However, the basic principles, I think in 70 to 80% of those cases will be the same. And that's what I'm going to discuss on the testamentary succession principles. The liquidity or the executability of your will, number 4, I'm just going to touch briefly on. I think it would be unfair if I don't discuss it in a wills presentation. However, it is part of estate planning, and it is a different webinar, part of the kind of series of wealth planning webinars that I do is the liquidity of your estate, or the executability of your will, however you want to look at it. But it's important to just quickly chat through that, and it's going to take a minute or two. As I said, if something triggers you when I talk about it, please get in touch or look out for the next webinar that will, look at that more in depth. And then lastly, just a couple of things around the formalities of all. Okay, so let's kick off with the basics. What are the basics? So basically we have 2 types of succession that I want to talk about today. It's 99.9% of what you'll see in our country. It's interstate succession, or intestate, however you want to pronounce it, and testamentary succession. So let's talk about testamentary. It's dying with a will, if I want to put it kind of in easy terms. So there's a testamentary succession, there is a will and testament, last will and testament in place, and we know what to do because it's been specified in that document. Intestate is then without a will. So the will wasn't valid, you never got around to it, whatever the case may be. The point is, you're dying without a document that can tell us and the powers that be how to handle your estate. And we're going to chat about that in the next slide a little bit more, so let me not stop here. Marital regimes is important. We have different marital regimes in this country. We have civil, that we're kind of used to, customary, religious, we have cohabiting as well. So we need to understand, or you need to understand, when you draw up a will, that there are sets of legislation behind these different marital regimes driving each of these. When are you a spouse? When are you not? What does that mean? Does that trigger a surviving spouse maintenance act or not, etc. So we need to understand each of these when a will is drawn up, because each of these have different implications in your will. Thirdly, spouse's definition. There's a couple of different pieces of legislation that is important here. Firstly, the Interstate Succession Act, that MSSA is the Maintenance of Surviving Spouses Act, Matrimonial Act, the Estate Duty Act, Pension Funds Act. And all these acts or pieces of legislation define potentially a spouse differently, for example. So we need to understand that when we do these, or draw up a will, and we say X, Y, or Z as a specification or a bequest or whatever it may be, within the will, what does that mean, and what is the implication of it? First from a marital regime, and then from a spouse, from there on to a spouse's definition, and how that will impact the executability of the will. All right, estate duty, I think we've all heard of, and executive fees, but let's just run it through it very quickly. Estate duty, as we know, is 20% for any amount above 3.5 million rand. So if your estate is less than 3.5 million rand, there won't be estate duty. So we do the calculation. We'll have a quick look at what is involved in that calculation a little bit later. But we do a bit of a calculation. We understand what the estate duty looks like, and you minus, the estate value looks like. You minus 3.5 million rand off that, and that is your dutiable estate. However, it comes with a couple of caveats, as most things do. One of it is the Section 4A abatement. What does that mean? Section 4A abatement is an abatement between spouses. So all the assets, the initial value of your assets, etc., carries over to the spouse, according to Section 4A. So if you leave your entire estate to your spouse, there is no estate duty, no section, because Section 4A is applicable, and you carry the entire estate across to your spouse. Your spouse also have that first 3.5 million rand free of estate duties. So what we do, or what you would do, is, because everything went to the spouse, so the second dying would then have whatever you didn't use of the abatement, the 3.5 million in the first estate, plus their own. So that means 3.5 plus 3.5 if we didn't use anything initially, then it's 7 million. So if you leave everything to your spouse, in a nutshell, the first 7 million in a normal world will be free from estate duty. Okay, anything above that, 20%. Anything then above 30 million goes to 25%. So there are estates that cross that threshold, and anything above the 30 million would be dutiable at 25%. Executive fees, 3.5%, excluding VAT. So it's important to understand if your executor is or is not registered for VAT. If they are, then you add the 15% VAT, which brings it to 4.025 or whatever it is. You can work it out. Percent, and that is the cost of the executor. I think two things there. Firstly, yes, you can always arm wrestle the fees down a little bit with your executor. And it leads me to the second point. If you want to, or your beneficiaries one day want to arm wrestle these fees down, it will make it substantially more tricky or difficult if you only do it after the time of death. Why? Your beneficiaries are going to be emotional. You know, the executor knows you're probably in a tight spot and they're not going to be as flexible, etc. Whereas now, before you die, there is ample opportunity to have this discussion, to understand what the fee structures look like for different sizes of estates, and you can potentially work um, uh, on a better fee schedule with your executor. That you can then write into your will with your executor, and it just makes life much easier. So that would definitely be something I would look at if I were you, to understand, to tie down your executor now already. I see too many times people nominating the executor as their kids or sister, brother, whatever. I have no problem with that. The problem is the master of the High Court. Not the problem, but the challenge is the master of the High Court requires two things. Firstly, you have to have experience, and secondly, you have to have the ability to wind up an estate. So those two things tell you that this person needs to have done this before. 99 out of 100 children have not wound up an estate before, does not understand it, what is needed, etc. And the master in the past, let's call it 10 years, will require that. So understand that even though you nominate your kids or somebody that you think won't charge an executive fee as the executors, the executor still needs to be appointed by the master, and those two principles will be looked at. And if whoever you nominate does not meet those standards, then you'll have to go out, or they will have to go out and find a co-executor that will charge fees. And as I said, to arm wrestle then is probably not the right time, in my opinion at least. Okay, enough said about that. Next one, you get first dying. Typically in any will, you get a first dying provision in the will. You get simultaneous death. So myself and my wife, we both passed away and leave the kids behind, let's say. Or you get what we call, and it's an ugly word, none of what we're talking about today is nice, but it's very important. But anyway, the third one is obliteration, or family obliteration, which means we're in a car, we're going down to a family holiday, and drive into a truck, and all of us die together. So if nobody is left, what happens to myself and my wife, or whoever is estate? Carrying on from that, if there's a simultaneous death, especially for children, but also people that can look after themselves, and there's a couple of definitions around it. Testamentary trust is the best way to tackle that, and I'm going to talk about that. You need a guardian for let's say your children. If we assume it's minor kids, you're going to need a guardian. You're going to need a follow-up guardian in case something happens to that person, and you're going to need a couple of trustees, and I'll chat you through that now, or in a few slides. Okay. Then what if I die without a will or with an invalid will? Well, there's an Interstate Succession Act. You can see which one it is. You can go and read it. It makes lovely reading. But the point is, interstate succession has a couple of nuances that you need to understand. So ISA there at the top in the darker blue is Interstate Succession Act. And MSSA is the Maintenance of Surviving Spouses Act. And you need to understand in which types of marriages does these apply. So civil marriage, yes. Interstate supplies, customary, yes. Religious, yes and no. As you can see, there's asterisks, and we're going to chat about the asterisks. And then cohabiting at the moment. No, however, there are always case law being tested in the courts, and these may or may not change at any point in time, as you know, as these get further developed, etc. But that's kind of what it is at the moment. Just that religious one, there's two pieces of case law which you can have a look at, or you can email me and I can send it to you. But it's Hassan Jacobs and Daniel Campbell. You can see it's quite old already, 2008 and 2001. But it goes, it's all about the Muslim traditional marriages, and those are the ones that I said there's a tick behind, because those two cases changed how they look at Muslim religious marriages, and that a spousal, the definition of a spouse will count as in terms of the Interstate Succession Act and the Maintenance of Surviving Spouses Act. But anyway, we can chat about that in more depth if need be. But the point is, there are some changes or some differences when you look at these ones individually. Then the next one is as I probably mentioned already, but in interstate succession is the same thing as testamentary succession. Is the master appoints the executor. In testamentary succession, if you have a will, the master will probably be much more lenient in terms of who's appointed as the executor. But in the interstate succession, there will not be a choice. He will appoint whoever is next in line, and those are state executors. Not that they're bad, they're very good, don't get me wrong. However, they have piles of paper on their desks, and you're a number, and you're in that line, and they'll get to you, and it takes time. The other thing you need to understand about the Interstate Succession Act is spouse or spouses. Some customary marriages has multiple spouses. The minimum is 250 and a child share. So if you have one wife, two children, and you have, let's say, 3 million rand estate, what will happen is the spouse will count as a child share, and the two children, so it's 3, the total is 3, and they will divide the 3 million rand by 3. And each one will get 1 million rand. That's how the Interstate Succession Act reads. However, a spouse has a minimum of 250,000. So let's say the estate is worth 300,000 rand, and there's the same scenario, 3 of them, one of which is a spouse, 2 children. The spouse has a minimum of 250. So the spouse will get 250,000, and the difference between the 300 and 250, which is 50,000, will be split between the 2 children. So the children will receive 25,000 rand each. And that may or may not be, I think in 99% of the cases, that's potentially not how the person who passed away would like his estate or her estate split. And then administration, again, in the interstate succession world, it's tough. So what I'm trying to show you in this slide is that I would highly, highly suggest that you get your will in order right now if you don't have a valid will. Then, a will. Then from an invalid will perspective, we're going to talk about this a little bit later, but there are instances where it was incorrectly signed, etc., and then the Interstate Succession Act applies. So when I get to what could constitute a valid will, and there's many more reasons, but some of which I will discuss here. just understand this slide applies the interstate succession again. Okay, let's talk about testamentary succession principles. And I always think this is easier to just show you with a picture. And all that this picture shows you is what we probably see in 70 to 80% of wills. And understand that any one of you will look slightly different to the next, but this is typically what we see in terms of the standard will. One, the first level is that first dying. Remember, I said, I hope you can see the cursor here. First dying, secondly, simultaneous, and then thirdly, obliteration. So if we talk about first dying, usually, not always, but usually the husband or the wife, whoever passes away first dying, just bequeaths everything to the other one. Okay, so then in my case, my wife will get everything, and then she can look after the kids. However, if she passes away with me, we went away for a romantic weekend, and that bus or that truck that I spoke about earlier drives over us, and we leave the kids behind. That's simultaneous death. What do we need, especially if it's minors? We need a testamentary trust. What does testamentary trust mean? It's a trust that lies dormant within your will. It's not a trust as we know it, or inter vivos trust, a living trust, whatever you want to call it. It's not a trust as we know it. That trust will then come into being with the will, with the execution of the will. So it doesn't cost you anything. There's no money involved. It's a part of your will, and this testamentary trust will then be a trust that will look after your kids. In that trust, there's a couple of things. There will be a bunch of stipulations that I don't want to go through now. It's too technical for this purpose, but there will be guardians or a guardian. So let's say my brother or whoever. But if my brother then passes away a year after I do, or myself and my wife passes away, there needs to be a follow-up as well. So we usually suggest a guardian and a follow-up guardian. And we're going to see it in the next slide as well. And then there needs to be trustees. Usually, typically people that you trust. The company that is the executor of the will can usually be one of the trustees, and I highly suggest that they are, because these guys know the in and outs, they understand the industry, etc. We do use a specific company for that. So if you wanted to chat to us about it, send me an email. But 3 trustees minimum. We usually suggest one is the company itself, the trust company themselves, and then 2 kind of either family or friends or people that you really trust, people that you feel that will really take care of your kids from a oversight point of view, that has the best for your kids, in their hearts, that wants to take care, or that will really want to assist and make sure they are looked after well by the guardian. So the guardian will typically say, I need to send this kid to high school, and there's going to be a cost to it, or they need to go into a camp, or this is a great tennis player, it's the next Nadal or Federer or whatever, and they need a really good kit, and we need 10,000 rand to buy all of this, whatever, and that will then be presented to the trustees, and they will approve it or not, or amend, or whatever the case may be. So the guardians don't just take the money, and that's kind of an important point in a will, that you also need to make sure how the will is drawn up, that there's 1 or 2 instances that it doesn't slip through. Maybe I can give you a quick example. I changed people's will the other day. It was an older wealthy couple, and they would the current provisions in the will, they have two kids. The current provisions in the will read that it will be split to the kids, and if not to their children. So they call it the grandkids. And let's just say there's one grandkid, just to make my life easy. So what's going to happen is in the will, it's going to go to, let's say, the daughter, and let's say the daughter has a daughter. So one grandchild on that side. So if the daughter passes away before this will, with this will still in place, and then the couple passes away, the money will go, should have gone to the daughter, but the daughter is already passed, and therefore now it's going to go one level down to the granddaughter. So that entire portion of the estate will now be, um, will now be the granddaughter's. The problem is, if we didn't put a testamentary trust in place for any minors that may benefit from this estate, then, and this may or may not be a good thing, but in this case, we thought it would be better to have a testamentary trust, because if she passes away, the daughter, then the daughter's husband, or the child's father, in other words, will become the guardian of the child by default. And if there's no testamentary trust in place, there's no oversight. So that money literally flows into the father's, the son-in-law, if we can put it differently, bank account. And you may have a great son-in-law that's gonna look after the kids correctly, or in some cases they're not that great, and they're gonna spend it on cars and the wrong stuff. The point is, it's out of your control if it's not in a testamentary trust. So when there are minors involved in any trust, I would highly suggest having a testamentary trust. Okay, then the next one is obliteration. It's probably the least likely. However, we have to talk about it, that if the entire family passes away, what happens then with the estate or the assets? And typically, they leave it to either the parents or the survivors of them. That means your brothers and sisters, etc. And those are kind of the three building blocks on which a typical will be built. All right. From there, let's just talk about some of these principles a little bit further. Testamentary succession principles. First dying, simultaneous obliteration we spoke about, testamentary trust, guardian, follow-up guardian, at least three trustees, one of which is a trust company, and two, close friends, family, we spoke about already. Usufruct is the right to use something. So you get these different words sometimes that we throw into for specific reasons that we throw into the wall. The usufruct, right of usus, habitatio, fidei commission, modus. So these all sound, foreign, and they are probably, but it's very simple in terms of what they mean. Right of use is just to say, if I give you the right of use of my house, you can use the house as you think. You can even rent it out on Airbnb if you wanted to. You have the complete right to use it. You can change it. You can add something. You can whatever. Take the pool out and put a fire pit in. Whatever you want to do. You have the right of use on that property for the period of time that is listed. Habitatio means you can only live there. You can't. So let's say it's a house at the coast, for example. Right of use would be you can go there with your family, but you can also rent it on Airbnb. However, if I only give you a habitatio, then you will only be able to go and live there. You won't be able to rent it out, or not live there. Visit there or go there on holidays, or even live there, but you won't be able to rent it out because you don't have the right of use. Fidei commissum is an interesting one. For example, you have a farm and you have two sons. One is not really a farmer, So he's I don't know, a lawyer in town. Um, the, the one son is with you on the farm every day, is a kind of farmer at heart. Um, in a fideicommission, you kind of rule from the grave. You say, look, my son that's on the farm with me, he's gonna be the next owner of this farm. However, if he passes away, it doesn't go to his children, or maybe you want it to go to one of his children. It doesn't matter, but it has to then, in that case, go to my other son, or something like that. So you specify that if this person passes away, it has to go to another person. The other one is modus, also an interesting one. I have, for example, a modus, or my dad has a modus in his will, and the provision there reads that the house I can have the day he passes away. I can have the house, but there's a modus, and the modus is if I sell the house, I have to reinvest that into property. So I can't sell it and go and buy a car or whatever. I have to reinvest it in property, and that's modus, one of them. But as I say, these are a couple of Latin names, and they have specific meanings within the world. This one is very important, and I think anybody that has any retirement fund, and the definition of a retirement fund in the Pension Funds Act includes a retirement annuity, your pension or provident fund with your work, any previous pension, provident, retirement funds that you have uh, resigned from and is now in a preservation fund of pension or provident preservation fund. Okay, so basically any, and I'm going to make it simple because it's just a little bit more technical in there, but any pension fund, when I talk about it now, is any pre-retirement product that saves for your pension. The whole rule that says you can take 1/3 at age 55, after age 55. The other 2/3 needs to be invested in some income producing asset, living annuity, life annuities, etc. So that's what I talk about when I say a pension fund. So pension fund, think RA, think pension fund at your work, think any provident fund not provident, preservation option you have, previous provident or pension funds. That's what we're talking about here, and that's what Section 37C refers to in the Pension Funds Act. Very important to understand, because I've seen this go wrong. What do I mean? Section 37C says the following. And I'm going to obviously paraphrase a lot here, but our law gives us the freedom of testation. What does that mean? Any asset I own, I can give it to whoever I want, right? Unless it's I'm married in community of property, right? In community of property means we own everything 50-50, my wife and I. So I can only give half of what I have in that case, but still I can have it. I still have the freedom of testation on that half. I can give it to whoever I want, or how I can distribute it in my will, however I want to do it. The problem is there is this piece of legislation in the Pension Funds Act, Section 37C. 37C says any pension fund asset. Remember what we just said, RAs, preservation funds, provident pension funds at work. Okay, any pension fund asset, you do not have the freedom of testation on. Okay, this might be a surprise to some people on the call, but if you have a retirement annuity, let's make it simple, and you say in your will, my entire retirement annuity goes to my wife, it does not count. You do not have freedom of testation on pension fund assets like the retirement annuity. What will they do? Any pension fund has whether that's retirement annuity, provident, it doesn't matter. Any pension fund, as I defined it already, has a board of trustees. Those board of trustees, according to Section 37, has an obligation to go and find whoever are your dependents. Okay, so you have a dependent. Anybody that's considered a dependent. Your spouse will be a dependent, by the way. She might out earn you, or he might out earn you by multiples in terms of they're not a dependent at all, but by definition of 37C, your spouse will count as a dependent in terms of the pension. Um, so your spouse will be a dependent. But anybody else that they consider a dependent, they have 12 months to figure out, and people can submit, and they're going to do some investigations, etc. But they have 12 months to figure out who dependents are. So if you have your parent, or your in-laws living in a flat in the back of your house or your yard, they will be considered dependents. If you're looking after your brother's son, that's gone off the rails a bit, and I'm just taking anything that pops into my head at the moment. And you're looking after him. He, monthly you give him a couple of thousand rand to make sure, he can eat. He's a dependent. Your children will be dependent, etc. Okay, all that I'm trying to say is when you write in your will that everything goes to my children, but I have a nice healthy retirement annuity, for example, and you know what, my wife is going to get my entire retirement annuity to look after her, in the event that I pass away, she won't get the entire retirement annuity. The board of trustees will look who are considered um, dependents. Those dependents, including your wife, they then there's a couple of steps that they go through. They look at their ages, their level of dependency, their current income, what else they there's a whole list of things they go through. But the point is, then they will decide who gets what, and there are many, many, many cases active at the moment where people dispute what they have done. Some people won these cases, many have lost these cases. But all that I'm trying to drill into you is if you think that you can just leave a pension fund asset to one person, you can't. If you only have, after we've gone through all the iterations, you only have one dependent, according to the law of section 37C, then yes, it will only go to your wife if that was meant for your wife, for example. But understand what it says. Any pension fund, so pre-retirement asset, in 1 or 2% of the cases, it can be post-retirement, but I'm not going to go into that now. Any pre-retirement asset, in other words, before you've retired from that retirement annuity, before you've retired from that preservation fund, or etc. If you pass away, that benefit, that cash benefit, they call it the death benefit, is subject to 37C, not to your freedom of gestation. They don't care what, they'll look at what's in your will and what you wanted and who you nominated, but it doesn't matter. You don't have the freedom to choose who that goes to. The board of trustees will make that call. So that has very specific implications if that's incorrectly written into your will, and you thought you can just leave that to somebody and then everything changes, and that somebody gets more than what you think they will, or less than what you think they will. Okay, enough said. Let's talk about the liquidity or the executability of your estate. Again, this is a different webinar. All right, it's the next one that I'm going to check you through. So it's an entire 45 minutes again. So I'm just going to fly through these points. All that I want to bring home is that whatever is in your will can be executable, or your will can be liquid or not. So there may be a shortfall. And I just want to trigger some of these things that you need to understand when you draw up a will that may cause a shortfall in your will that makes it not executed, or illiquid. All right, let's run through them. We've already spoken about marital regime. Understand that in community of property looks different to anti-nuptial contract. ANC is not political. Anti-nuptial contract. So ANC with accrual or without accrual. Understand these things all mean different things, and when you have it in your will, uh, they get applied differently. All your liabilities will get deducted. Estate duty, as we discussed earlier, will be deducted. You have to have a have a good understanding. If you have business interests, i.e., you're a you're a shareholder at a company, or you are a key man in somebody's company, you need to understand that business interests can have an impact on the amount of estate duty you pay. So if you suddenly have a 10 million rand business interest, shareholding, and there's a buy sell policy in place. In other words, your wife is not going like me. My wife has no interest in what I do. And if I have any business interest, she won't want it. So we need buy and sell policies in place to make sure it goes to, the correct people, my previous partners or new partners we define or whatever. The point is there are these nuances in terms of business interests that you need to understand. If they're not correctly structured, and there's a couple of reasons, they could potentially not be correctly structured, and I talk through them in the next webinar, but that will attract estate duty. Now, if you suddenly have this extra 2 million rand estate duty you need to pay, that may make your estate illiquid. And you're gonna, or your beneficiaries of your estate will have to sell policies. Oh, sorry, policies. I'm thinking about these buy and sell policies. Will have to sell assets, and that may be a family home or whatever. Um, Understand that business interests may trigger estate duties, and you need to understand how it works. CGT is capital gains tax. Remember, if it doesn't go to your wife, I referred to the section 4A abatement already, that if everything goes to your wife, that base cost of the CGT carries over to your wife. So it's no problem if it goes to your spouse or wife to husband. When it moves to your spouse, section 4A abatement applies, so no CGT. However, if it goes to anybody else, there is a CGT event. It's like realizing whatever profit there was. If you've had this house for 40 years, or it's a share portfolio, or whatever it is, there's CGT implications that you need to take into account, because the taxman will come and ask for the tax on those gains. Maintenance claims. Understand that there's this, and I alluded to it earlier, MSSA, the Maintenance of Surviving Spouses Act. Understand that it's a piece of legislation that you cannot get around, and we've seen it. The wife, I'm just taking random examples now. The wife and the husband don't like each other anymore, and let's assume, just for the purposes of this one, the husband was kind of dependent on the wife. Wife had a good estate, and a good job, who looked after the husband mostly. It's a stay-at-home dad, let's say. And they picked up some trouble along the way, whatever that may mean. And the wife doesn't like the husband anymore. And therefore, she writes him out of a will completely and say, everything goes to my kids or my sister or my parents or whatever, but my husband will get nothing. And the day happens, the wife passes away, husband stays behind, and then this thing comes into play called the Maintenance of Surviving Spouses Act. And the husband is a surviving spouse, and he has a claim on the estate, and it ranks above most of the others. So understand that even if you write your floozy into your estate and write your wife out of the estate, it doesn't work that way. So there's maintenance claims that It may or may not be. And I'm taking the controversial example now. There are many examples for maintenance claims that are very valid. Um, I'm just taking the surviving spouses one as an example here. Point is, the maintenance claims needs to be part of your estate and your executability of your will. So if you leave everything to people and there's a maintenance claim coming in and that has to be settled first, you're going to have to sell assets. Those assets may not want, you may not want to be sold. So all that I've showed here is different problems that can pitch up, or challenges that can pitch up in an estate that you need to address in your will. And there may be a shortfall due to this. So I like using the example. It's a dad. He was very wealthy, and he had, let's say, a 5 million rand house, and he had a 5 million rand vintage car, and he has two sons. The one son is, this 5 million rand family house has been in the family for generation, and the other son, he had this, this passion for vintage cars, and this 5 million rand vintage cars needs to go to the other son. However, dad lived through all his money and basically spent the last one, the last cents on his deathbed. In other words, there's nothing to service his state duty. But his will reads, my house goes to my one son, the family house, my vintage car goes to the other son. What happens now? There's only two assets in this estate. There's a shortfall. That shortfall needs cash. What's going to happen? Well, either these kids are going to have to, pay for that, which, millions of rands we don't always have lying around, I think. Congrats if you do, but mostly not. Therefore, either one of these assets needs to be sold and liquidated. And is it the vintage car or is it the house? And then that's where family fights start. So I'm trying to say a will has implications. Make sure it's liquid or executable. Good. I see I'm running out of time. Let's quickly run through formalities. Signatures, very important. Every page needs to be signed by the testator and testatrix. Every single page must be signed, actually initial, but I usually say sign every page and the last page. Competent witnesses needs to be present, 2 of them. Competent witnesses older than 14 years. For example, there's a couple of rules around the definition of a competent witness. They need to be present. They only have to sign the last page, but again, rather just sign all of them, at least initial all the pages. Beneficiaries. When you're a beneficiary of a will, do not sign as a witness. So I shouldn't sign my parents' will, or any beneficiary on that will should not. If there's anything that goes to you, do not sign that will. It's not against the law to sign that will, but if you do sign it, you fall within the Interstate Succession Act. So if you're a beneficiary and you're a spouse or one of the children, fine. It probably can work, but it's going to be be governed by the rules of the Interstate Succession Act. Understand that. So it's just easier to remember the following. A beneficiary of an estate, if you're a beneficiary, do not sign that will. Get other witnesses, competent witnesses, to sign the will. Storage, usually say three copies. One goes to the trust company, one stays with you, and the third one goes to a family friend or family or the financial advisor or whoever. But kind of have 3 copies that, if one gets lost, the trust companies have fire retardant safe. They have, it won't get lost. Highly unlikely, but in the case that it does, make sure there's a copy of a valid will. The other thing that I just quickly want to note here, that only popping into my head now, is make sure that if you have international assets, and those international assets are governed by an international will, when you write this will, do not write in the will. Usually the first paragraph reads that This will recall all and every previous will I've ever signed, written, whatever, stamped. Make sure that it excludes your offshore will, your international will. Because if you now sign tomorrow a new local will and you put that clause in without excluding international will, you've just recalled your international will as well. And everything, and they may be completely different. I just thought I'll mention that quickly. Okay, guys, thank you very much. I'm not going to go through process now. If you need to drop off, you're welcome. If you want to send through some questions, you're welcome. I did receive a question quickly. I just received a question already from one of the attendees, and I would like to answer that. You're welcome to send any other through. And so I'm just going to quickly start with that. The question is, if you have a trust and a company, where or how is the best way to specify who takes over the trust and a company? Okay, so important. Let me start here. It's important that when you do a will, there are a couple of documents that you cannot draw up a will without. One is the trust deed, if you are involved in any trust. Second one is your company memorandum of incorporation or any buy or sell agreements, if there's third parties, if you don't bequeath it to somebody, etc. Those documents important. And then also the marriage contract. I've literally seen people, and I've actually heard a horror story where a whole financial plan was done, will was drawn up, thinking that the marriage was in a certain way. I think it was anti-nuptial contract without accrual. So obviously, if it's not, everything changes. And the husband passed away, and I realized the, they were married in community of property. It's actually a foreign couple that immigrated here. And that obviously changed the whole board. So just understand, without those documents, you cannot do anything from a will perspective. However, let's answer the question. There's a trust. This person has a trust and a company. How do I specify who's taking this over? I'm going to start off by saying all the documents need to tell the same story, firstly. Okay, that's the safest. Secondly, a trust is a separate legal entity. You don't own anything anymore. So the trust deed will and must stipulate, capital beneficiaries, income beneficiaries, follow-up trustees, whatever the case may be. So from a trust perspective, the correct answer is a trust deed. The trust is a separate legal entity. What you write in your will about the trust doesn't care what a different legal entity says about it. So trust deed. Company, a little bit different, remember, because now you own an asset. And in a trust, you don't own any of those assets, right? But in a company, you are the owner of the asset. So the answer, I'm going to give two answers. Just if you're going to bequeath it to somebody within your family, then it is your asset. It is an asset in your estate, and you just bequeath it to whoever you wanted, your wife, children, whatever. Understand all the implications that I referred to already, but point is you can bequeath it because it's your asset. If it's not, if you don't want to bequeath it and you rather want to, as I explained earlier, you rather want to get rid of that asset in your estate and you want to move it to somebody else. Let's say you're a partner with another guy, 50-50 partners. He's not a family member or anything, he's just, buddy. And you want him to buy it, there must be a buy and sell agreement in place that, that partner may have the cash to buy it from your estate or from your whoever, let's say your wife would have been the new owner. So then your wife or your spouse rather gets the cash, and then there's a buy-sell agreement governing that. That can be written in the will to refer to the buy and sell agreement. So the answer is all the documents. So in this case, there are 3 documents: the trust deed, the company potentially buy and sell agreement, and just check the memorandum of incorporation here, because it may or may not happen that the MOI says that any share must be first offered to co-shareholders. Then you can't just um, bequeath it to your wife if she's not already a shareholder. So it needs to first then go to co-shareholders. So just make sure there's no funnies. Typically not, but just make sure. And, 9 out of 10 MOIs are just standard. Okay, so trust deed, company, buy-sell agreement. If it's going to be taken over, and then you can talk about some of these things in your will. The trust won't care. The company may or may not. Just again, make sure of any estate duty implications in both instances. So I hope that answers the question. Let's see if there's other questions. Okay, so there's a question here with a trust at your death. If you want to dissolve the trust and the heirs want the assets out, is there CGT, etc. Payable? Correct. There will be CGT consequences. Let's see. Last time I think I missed something. There's a Q&A here and then there's a chat there. Let's see. I missed the chat last time. No, I don't want to chat. Any other questions? Okay, I will still look out for questions, but if you want to send us an email or phone or whatever, you're welcome to. Happy to answer any more questions. Thank you very much. Appreciate your time, and all the best.